পিছত মোৰ মা আমিষা বিবি 61 মোক বচাব যোৱাত পদকী এজনে কাঠৰ বাটামেৰে মাৰপিট কৰি গুৰুতৰ জখম কৰে। So, Lordship, what happened? The incident happened on 10/1, Lordship, 10th of January. But Lordship, kindly peruse page 11. FIR lodged on 17th of January, Lordship. Page 11, kindly. Date of occurrence on 10/1/2026. FIR received on 17/1/2026, Lordship. The Lordship, quarrel between two young son and daughter of the informant and the accused, Lordship. And they are immediate neighbor, Lordship. Petitioner thereafter, Lordship, arrested on 17 itself, Lordship, because she was at home, Lordship. There is a quarrel between the parties, Lordship. And I am always lady, Lordship.
Let the CD come, Lordship.
After 7 days of incident, no explanation whatsoever, Lordship. The FIR.
Where is the forwarding report?
Forwarding report, page 21, Lordship.
Affecting persons are grievously injured and referred to DMCH.
Lordship, we have stated in our petition, Lordship, and she was taken to hospital on 11th of January, and on that same day, Lordship, after treatment, Lordship, she was discharged, Lordship. But FIR lodged on 17, Lordship. And the petitioner and her minor son also got injured, and they are treated, Lordship, in the hospital on 10/1, Lordship. We have annexed in our petition, Annex 2 and 3, Lordship. Physical assault, Lordship. Page 17 and 19, Lordship.
Learned counsel for the petitioner. LPP. Decision application under Page 21, background of the cases. All for the CD. The present petitioner, lady, aged about 50 years. The allegation of assault as reflected in the FIR is not specific to the present petitioner, who is the mother of 2 minor children. Of having regard to the nature of the allegations and a period of detention of about 12 days in custody. That the petitioner so and so shall be released on interim bail of rupees 50,000 with one surety of like amount. Satisfaction of the learned Elaka magistrate in connection with the aforesaid case. Is the matter again on
I am obliged.
Kindly pass over for the time being. My senior is coming. They have received the instruction that charge sheet submitted. Yesterday it was listed, Lordship, but we are taking time. After some time, Lordship, my senior will argue. Wait, please, Your Lordship. This is a pre-arrest bail application, Your Lordship. But this petitioner, Your Lordship, is a young boy of about 25 years old, Your Lordship. And the faithful day affair, Lordship will get at page number 9, Your Lordship. May I read, Your Lordship?
CD.
This case, the petitioner is not the main accused, Your Lordship. Who is
However, it is dead.
13-2.
Can it be a little bit?
As far as I know, 11-2. Oblige, Lordship.
My lord, this is an affected under section 482, my lord. And in this case, my lord, the petitioners are from the same family, my lord. My lord, the petitioner has a plot of land, my lord, in which they cultivated paddy, my lord. And in this same plot of land, my lord, is my lord, claimed by the informant as their own, my lord. And as a result of which, on several occasions, my lord, disputes have taken place, quarrel have taken place, my lord. On 12/11/2025, my lord, the informant's family, equipped with, my lord, sharp weapons, they visited the paddy field and cut down the paddy, my lord. When they got the information, my lord, the petitioners immediately rushed to the, my lord, field and requested not to do that, my lord. But at this, my lord, Marpit took place. And the petitioner's side also severely injured, my lord. One, the petitioner brother and his mother got severe head injury. And the petitioner number 2, my lord, his fingers of left hand were cut down, my lord. And in this, my lord, Marpit also, my lord, the son of the informant's family, informant, my lord, died, my lord. Thereafter, my lord, they got received, my lord, treatment at GMCH, my lord. Thereafter, my lord, the informant lost the affair, my lord, and on the same day, my lord, the petitioner also lost the affair, my lord. So cross affair is there, my lord. In this regard, my lord, one title suit is also pending before the, my lord, civil court, my lord. Only the cause is that the plot of land is mutated in the name of the petitioner's family, my lord. The always quarrel took place between the both the families, my lord. They are both are related, my lord. Now, my lord, two of them, my lord.
Anyway, it is 103.
No, my lord.
CD.
They may be protected, my lord. There is no male member, my lord, in the family, my lord.
Good.
May I appeal, Your Lordship? My lord, FIR lost, my lord, on, my lord, 4/11/2025. Now, police, my lord, searching me, my lord, last 1 week, Lordship. My lord, page number 20 is the FIR. May I read, Lordship?
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা 3/11/25 তাৰিখে ৰাতিপুৱা অনুমান, মাইলৰ
ৰাতিপুৱা অনুমান 3 মান বজাত মোৰ ডাঙৰ ল'ৰা সন্তোষ কুমাৰ চৌধুৰীৰ লগত নিম্নলিখিত পদকীয়াগণৰ কিবা সৰু সুৰা বতৰা লৈ প্ৰায় তৰ্কা বিতৰ্ক হয় আৰু অলপ পিছত পদকীয়াগণে মোৰ ল'ৰাক হাতেৰে বাঁহৰ লাঠিৰে লোৰ ৰডেৰে আৰু ইটাৰে মাৰপিট কৰি গুৰুতৰ জখম প্ৰাপ্ত কৰি ৰাস্তাৰ ওপৰত বাইলেন ওচৰত পেলাই থৈ যায়। পিছত মই আৰু মোৰ সৰু ল'ৰা বিজয় কুমাৰ চৌধুৰীয়ে চিকিৎসাৰ বাবে ধুবুৰী মেডিকেল কলেজত লৈ যাওঁ, কিন্তু ডক্টৰে উন্নত চিকিৎসাৰ বাবে গুৱাহাটী মেডিকেল কলেজলৈ এণ্ড হস্পিটেললৈ প্ৰেৰণ কৰে। মানে হোৱাট ইজ হেপেন মাইলত ভিক্টিম ইজ দ্য মাইলত হেবিচুৱেল ড্ৰাংকাৰ লৰ্ডশ্বিপ। He মাইলত on the day of মাইলত incident মাইলত he মাইলত come to our gate মাইলত at about মাইলত 12 a.m. and মাইলত he shouted মাইলত in front of our gun. Then when we went to the মাইলত gate মাইলত he মাইলত challenged with a মাইলত big মাইলত. Then we challenged মাইলত then he rushed away lordship. He fell down in মাইলত in a drain lordship. Therefore he sustained some injury lordship. That is the fact lordship. Moreover মাইলত kindly look মাইলত the time মাইলত 3 a.m. মাইলত in the morning মাইলত. Moreover মাইলত petition number 1 is the মাইলত lady lordship.
Later on 103 section added.
Yes, that is not disputed.
103 that means
Matlab, after 15 days, matlab, he died matlab, in the Guwahati Medical College. Matlab, petitioner number 1 is a lady lordship, age at about matlab, 50 years. Matlab, FIR lost matlab, in the November lordship. Last matlab, 1 week matlab, police searching me lordship, ask me lordship.
You can wait from November, you can wait for another week.
Lordship, matlab, at least matlab, to the lady matlab, protection will be
No.
given matlab. To the lady.
Give it HCD.
Good. Leave leveless.
Lordship, that is a matter for time being or not. My senior is in leg in put number 80 plus.
Everything also. So FIR is at page 16 now. May I read now? পূৰ্বক বিনীত নিবেদন এই যে গত 11-25 তাৰিখে প্ৰায় 7:30 মান বজাত ঠাই ঘৰত নথকা অৱস্থাত মোৰ বৃদ্ধ আইতা শ্ৰীমতী সোৱেঞ্চ কিছু গা ভাল নথকাৰ ইংৰাজ 4 আলিত চেম্বাৰ খুলি বহি থকা চিকিৎসক শ্ৰী স্বপন দাসগুপ্ত নামৰ ডক্টৰজনক মোৰ ভাইটিয়ে ঘৰত মাতি আনি মোৰ আইতাৰ চিকিৎসাৰ বাবে কোৱাত উক্ত ডক্টৰে লগে লগে মোৰ আইতাৰ কোনো ধৰণৰ ফুটপোচ নকৰাকৈ হাতৰ শিৰত বেজি দিয়াত বেজি দিয়াত খন্তেক পিছতে মোৰ আইতাৰ মৃত্যু হয়। আমি একেবাৰে অজ্ঞাত যে এইজন ডক্টৰে ভুৱা প্ৰমাণপত্ৰ লৈ চিকিৎসা কৰি আছে ৰোগীসকলক নকল দৰৱ দি ইয়াৰ আগতো জনামতে কেইবাজনৰ ক্ৰমে দৰৱ দি মাৰি পেলাই মোৰ আইতাকো ক্ৰমে এনেধৰণৰ ভুৱা চিকিৎসা কৰি হত্যা কৰে। গতিকে দয়ালু মহোদয় ইয়াৰ এক উচিত তদন্ত কৰি উক্ত ডক্টৰজনৰ আইনমতে বিহিত ব্যৱস্থা ল'বৰ বাবে অনুৰোধ কৰক। দেৰ যে নোট মেলত মোৰ আইতাৰ ডিব্ৰুগড়ত পোষ্টমৰ্টম তথা সৎকাৰ কৰা কাৰ্যৰ সময় লোৱাত এই বিৰুদ্ধে পলম হয়। So, my lord, that incident occurred on 25th of November at around 6:30. The affair was lodged on 27, my lord. What I am on is, my lord, that he is a, my lord, Ayurvedic practitioner, my lord. He has been practicing there for last 15-20 years. There has been no record of any, my lord, misdeed. Now, my lord, that day, he was being brought to the home, my lord, by the informant's brother. And when he arrived, my lord, the victim was already in a critical condition. He advised them to send her to the medical college Dibrugarh. But instead of that, my lord, they insisted that a injection of acidity problem, my lord, that may be injected to her. But he refused. And after some time, my lord, he came to his home nearby, and he had the knowledge that she died. And this is absolutely cooked up story, my lord, that he had pushed some injection on her. So that is a cooked up story. So accordingly, my lord, he was taken into custody on the very that day, on the next day, my lord. And today, he is, my lord, around 62 days behind judicial custody, my lord. 62 days. So, my lord, one aspect, my lord, even if we go by 105, there are two parts, my lord. If it is not intentional, then it is up to 5 years, my lord. 5 years, it can be extended to 10 years. But, and rest of the section, my lord, 3192 and 36.3. Cheating by personation and forgery is a matter of trial, of course, my lord, but these are up to 5 years and 7 years. So, my lord, going by that, maybe, my lord, length of detention is already exhausted, my lord, 60 days.
105.
105, my lord. It says, my lord, may I read? Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life or imprisonment for either description for a term, which shall not be less than 5 years, but which may extend to 10 years, and shall also be liable to fine. If the act by which the death is caused is done with the intention of causing death.
It's a 60-day offense, PP.
Death is caused, then
No, intention is important, my lord. Prima facie, he has got no intention, my lord. He's a fake doctor or not a fake doctor, that's a different thing. But he has no intention to kill the victim, my lord. And this is also, my lord, disputed, my lord. He did not inject any, my lord, injection, my lord.
Whatever minimum punishment is not 10 years,
not
Not
10.
10 years.
then
60 days, my lord. My humble prayer, my lord, may be released on bail, my lord. If my lord decides to call the CD, even then, my lord, he may be released on interim bail, my lord.
Mandatory period is about, we have to go to the instruction whether any subsidy submitted in this real. So after I have to. But I'll take the instruction whether it's subsidy.
try to get the instruction if
Look.
charge sheet has already been submitted or
Okay.
not. We'll take up before 2.
Look.
At 2, my lord.
Before
any-
2, it will come.
The instruction I get. Right before 2.
Always.
First.
Wait, please, your lordship. What's the pre-arrest bail, my lord? The lordship will find the FIR, my lord, at page 9, my lord. Yeah.
I think we had a similar matter yesterday arising out of the same FIR.
Why I'm apprehending, my lord, that is at page 17, my lord. Page 17, my lord. The bank statement, my lord. Fourth column, my lord. 5,000 rupees has been, my lord, credited to my account, my lord. Fifth line, my lord. Fourth line, my lord, I'm sorry.
Amen.
Yes, my lord. Amen, my lord. I am not aware of that, my lord. Interim decision.
All right, CD.
Any interim, my lord?
I'm quite sure CD will reveal your involvement.
Fine. Short date. I am obtained.
Lordship. Lordship, I am appearing for respondent number one. Lordship, my senior is unable to attend the court due to the medical emergencies. So kindly fix it in the next dates. In the next week, Lordship.
The prayer of learned counsel for the respondent has cited medical cause in respect of tenure. Is the matter again on
There is an interim order.
interim order passed earlier to continue till next date.
Please, your lordship. As per note sheet, lordship, TCR has not been received, lordship, till date.
Here is received, I think, 11.
Yes, lordship.
And TCR has not been received.
I have a small prayer, lordship, interim may be continued till further order, lordship.
Web till further order.
Instead of till next date, lordship, till further order, lordship.
Why? Means the same thing. Interim order till the next date of listing.
Fine. Oblige, lordship.
Well, this is challenging the impugned judgment that is from operative part is my lord 55 onwards, whereby my lord amount 4,000 per month has been allowed and 15,000 cost has been printed, my lord. Why I am before you?
Record not called for. Order is there, not necessary.
But actually, there is
Is-
some. What is necessary?
Huh?
Necessary, my lord. Record necessary.
But there is no order calling for the record. Heard learned counsel for the petitioner. Learned additional PP. Call for the scanned copy of the TCR list again. On
Oblige. May I please, your lord?
yes,
But in this case, the petitioner has come against the Milord order of enhancement of maintenance, Milord. That is order impugns hearing is your lordship will find at page number 163, Milord. Is Milord annexure 11.
one.
163, Milord. Earlier, Milord, it was 5,500 allowed, Milord. Then the respondent, wife, Milord, preferred an application under section 127 CRPC seeking enhancement, Milord.
Hmm.
And in that, Milord, enhancement proceeding, Milord, the amount was enhanced from 5,500 to 10,000, Milord.
For wife
Yes, Milord.
and child.
Wife and one son is there, Milord.
Yes. What is
Uh,
your income?
My income is, Milord, 51,000, Milord.
But the fact is that, my lord, I have some other liabilities also. And so far as the bank accounts of both the petitioner and the respondent is concerned, my lord, that the amount, my lord, available in the account appears to be, my lord, same, my lord, that the petitioner also does not have that sufficient means. And that, my lord, comparatively, if we compare the statement.
What
of
is
the-
your source of income?
I am an FEBN, my lord.
Eh?
Constable, my lord, I
Government servant,
government servant,
51,000,
51,000,
10,000
my lord,
for wife and child.
my lord,
Will you withdraw it or do you dismiss with cost?
my lord.
Frivolous applications.
Yes, my lord, my only, it is or subject to approval of your lordship. my lord.
10,000 cost dismissed.
Basically, with regard to the my lord arrear, my prayer would be, my lord. So far as the arrear is concerned, I have been directed to.
Why would you not pay arrear?
I shall pay, my lord, but some accommodation would be needed, my lord. Because I am also, my lord, patient now, and I have some medical, my lord, constraints. My old aging mother is there, my lord. Therefore, I am not in a position to clear the amount, my lord, as it has been directed. So,
Is your child.
my lord. Your lordship is pleased to make some observation with regard to the arrear, my lord. Then in that case, it would do.
What
it.
is the arrear?
My lord, actually, it has. I am regularly paying the, my lord, monthly, my lord, but arrear is not calculated, my lord. But from the date of the application, it would.
Yes, respondent, what is the arrear?
There is your lordship, the petitioner has been paying only rupees 5,500 till date, your lordship. Arrear is not calculated yet, but if you calculate, then from the date of filing, it will be a very high amount, your lordship.
Therefore, my lord, I am seeking some accommodation, my lord.
Is that the way to apprise the court? Dated order
My lord, 4/2/2025.
2025,
The arrear will be 4,80,000.
whereby the maintenance amount granted earlier to the respondent, the child, was enhanced rupees 5,500 per month to rupees 10,000 per month. The petitioner submits that because of financial constraints, he is not in a position to pay the arrears one go and seeks accommodation with respect to the arrears of maintenance. Accordingly, and as agreed to by learned counsel for the respondent, this petition is the section that the arrear amount said to be amounting to rupees 4,80,000 as of date shall be paid in 12 monthly installments to the respondent by the petition. The monthly maintenance amount of rupees 10,000 stands affirmed, granted by the family court stands affirmed. Petition stands accordingly.
Kind of
I'm obliged.
Definitely. Kejriwal was called for in this one.
The Kejriwal is asked now, Lordship.
The case of suspected foreigners, my lord.
Yes, what have you got?
Lordship, you have received a case diary in us now, Lordship. You have to go through it, Lordship. With another date, Lordship, day after tomorrow on Monday, Lordship, I will go through it and dispose it of, Lordship. Monday.
The prayer of learned counsel for PP seeking time to peruse the CD. List the matter again. Wednesday, next Wednesday.
Right.
All right. 4/2.
All right.
My privilege.
in this case, we have challenged the order passed by the learned special judge extending the time for investigation. Impugned order is at page 57. As a ground, this report is not without application of mind and satisfaction of mind, and no notice was served to the accused persons, nor he was produced before the court either personally or virtually at the time of hearing. Although they have now filed the charge sheet on 22nd, Lordship, but situation remains the same. If the extension is illegal, then we have some right.
May I please, Your Lordship, we've received a report from the department, Your Lordship, regarding this extension. As per that, Your Lordship, their contention that the act of the public prosecutor was incorrect and misleading, Your Lordship, that has been denied by us, Your Lordship, in the report. Also, Your Lordship, the charge sheet has been filed, so we will produce the CD within the next 2 weeks, Your Lordship.
It is not required, Lordship. It is the order, and I am from the record and recent case laws.
Lordship, the extension was sought well before the expiry of 180 days, Your Lordship.
You're given notice.
That is, I am disputing, Lordship, because how last paragraph, learned special judge as mentioned, also in the applications, the received by copy was received by certain advocates. Now there is no okalatnama of this petitioner engaging any of these persons. Now, even if, Lordship, any bail petition is moved and it was rejected, can it be said that this counsel is representing these accused, any accused persons before the court? Because their bail petition is disposed of, is rejected. And the law says, Lordship, recent 22 decisions, Jigar, relying upon the previous three judges mentioned.
Where from do we get that?
Lordship,
Where from do we get that? Whatever he was submitting, who has received it, some other council has received, or whoever, where from do we
no,
get that?
in their application, I am submitting that there is no okalatnama by the petitioner. That's why a record was also called for, Lordship. In paragraph page 52, this is the application submitted by the learned special public prosecutor, and there is received, there is some signature received copy.
Where?
Page 52, Lordship. I instructed my counsel before who engaged me to search for the okalatnama. There is no okalatnama engaging by TG Liana or any of the advocates, Lordship. The record is also important. The left side, one is illegible, received with objection, and another is received with some there were something.
If Your Lordship may have a look at paragraph 7 of the report, Your Lordship.
My conditions, this does not amount to service of notice to the accused person. Because it is an investigation stage. That is, its trial has not started.
Where is the question of trial here? It is for the purpose of investigation only the time has been
Yes, yes,
sought.
that's why how an advocate can receive copy for me, on behalf of me. Even if there is my Okalatnama is there, it's okay. I cannot say anything if there is my Okalatnama is there.
You cannot be represented during investigation stage when the case is before the court.
Even if my Okalatnama is there, then it's also okay, but there is no Okalatnama of mine, Lordship. And during the investigation, if I engage anyone, it's okay, but during trial, we cannot dispute if there is Okalatnama. A copy is served upon
Then
us.
we have to call for the record.
Record was called for earlier also, Lordship, this I think.
Prima facie, it appears you were given notice. So
No, I will, Lordship, submitted 2 decisions. It says that it should be heard in presence of the accused person, either virtually or personally. And this is 2022 decision, Supreme Court, Lordship. And another aspect is
whether
that
he was present or not will also be revealed by the record.
it apparent from the order itself that he was not present.
Necessarily.
Today is fixed for hearing, filed by the complainant. The Customs Prevention for Research to Learn Special PP praying for extension of time in respect of the statutory period. Then what is stated in the petition? Only reason has been given that since the petition has been filed before expiry of the statutory period, so it has been extended. This is the only reason. And in the application of the learned special public procedure, there is no application of mind and satisfaction of mind, which is important. And that part is also dealt with by these 2 decisions.
Cannot straight away say there is no application of mind because
This is my
the
submission,
or-
Lordship.
Order has
Submission,
been,
Lordship will examine, decide it. It is my submission, there is no application of mind because
order has reflected the grounds on which the petition has been filed.
it does not say, Lordship, why the further detention is necessary. And he does not say he is satisfied. After application of mind, he is satisfied that there is ground for further detention and extension of time. That has to be there.
He has said that they're citing valid and reasonable grounds. We can't ask the judge to write in the language you want.
No, I'm not submitting about the judge, Lordship. I'm submitting about this application submitted by the special public prosecutor.
That is his way of showing application of mind.
Law says how to do it, Lordship.
Not necessarily in
Law
the
says-
language you want.
That's why I'm relying upon 2 decisions which says how to do it, Lordship.
What has the Supreme Court given a format?
Not format, but application of mind has to be mentioned and satisfaction of mind.
Where is the decision?
I have submitted 2 decisions, Lordship.
Jigar.
Jigar, Lordship, in Jigar, this 1994 special 3 judges, Hitendra Thakur also
Paragraph.
relied upon, Lordship. Lordship, may paragraph come to paragraph 23, Lordship. Paragraph 23, Lordship, may page 13, bold part, second bold part may kindly be read, Lordship. That is bold, page 13. The public prosecutor may attach the request of the investigating officer along with his request or application and report. But his report as envisaged under clause BB must disclose on the face of it that he has applied his mind and was satisfied with the progress of the investigation and
That is with
considered
regard to the PP.
PP. Now here in our case also PP has filed the application.
We are talking about the judicial order.
So if the application both has to be examined, Lordship. If the report application is without application of mind, it cannot be considered by the learned court also, designated court also. We develop our argument, Lordship, on the basis of the decisions and law. That is what I am submitting.
All this is about report of the public prosecutor. We are on the order passed by. You are just now submitting the very language in which the judge should have written the order.
No, Lordship.
Now you are taking us elsewhere.
I was submitting on the report,
All
page
right.
52.
Call for the record. Don't change your version. Everything is on record. You're referring to the order, not to the application.
But regarding order, I have submitted that the only reason is given that statutory period is application is.
It is not the only reason given. He said he is satisfied with the reasons given by in the application.
Yes, if that application is without application of mind,
Now you are coming to that.
so that is I am from the application.
You were taking us to the Supreme Court on the basis of the order passed by the court.
No, I am
That
taking.
How it is
Lordship,
not in accordance with the order
I am
passed by
taking
the
Lordship,
Supreme
both
Court.
application as well as the order.
Get your mind clear first before submitting. TCRS call for has not been received. List again on.
Wait, please, your lordship. Lordship, a charge sheet has been already filed. Humble prayer to call for the TCR record, lordship.
It is submitted that charge sheet has already been filed. Filed CS number
272/25 dated 28/1/26.
call for the scanned copy of the TCR. List again on.
Highly obliged, your lordship.
I think also same prayer also, charge sheet certificate.
Yes, so this 60 days, Bhendu Lordship, they may be allowed to file the fresh petition before the learned trial court, Lordship. I may be allowed to file a fresh petition before learned trial court, Lordship.
Yes, sir.
What is here submitted?
CS has already been submitted on the learned counsel for the petitioner. Submits that he will file fresh application before the learned trial court. Accordingly, the present bail application stands closed.
File CS number 3/26 dated 27/1/26.
Obliged, Lordship.
Thank you, Lordship. Petitioner is on interim. We have not received the case diary. So he's an interim also, no? He's an interim, Lordship. CD not received. Case diary not received. He's on interim.
They are on intense lordship.
CD not received. Please
seven.
again on so interim order passed earlier to come.
18-2. Please, the loss. Case day was called for 482 application lordship. Petition number 1, he is on interim. Petition number 2 is he is not on interim.
Lordship, CD. is
Regarding that
lordship.
diversion of money into the account. Lordship, you kindly see the statement of the main accused, Sanjay Tamuli, because he is the brother and son of the petition number 1. So he has diverted some amount from fishery department to their account. Thereafter again he has taken away. So he is solely responsible. Only their accounts are used. Because the mother's account he used to maintain and brother's account also sometimes he used to maintain. So from Fishery Mission Society, some amount was entered into these accounts. And thereafter again he transferred back to his own account. I have annexed the statements also. Also kindly see the statement of the main accused Sanjay Tamuli. That will reveal everything.
Lordship, interim was granted lordship. And lordship, as per the interim order, lordship, dated
Main accused is named.
Main Sanjay Tamuli.
Sorry. And this petition is on behalf of.
The mother, mother is Dipali Tamuli and Vijay Tamuli.
Vijay
He is the brother.
Kindly peruse lordship para 10 and 11 of bail objection lordship. He has not complied with the terms and condition of the Honorable Guwahati High Court imposed upon him in the order dated 12/11/2000.
He was not granted in time, that's why.
AB
Last date your lordship has clarified that.
him to cooperate in the investigation, lordship. Otherwise, also sufficient material, lordship. Kindly pay sufficient materials against him. Also, details of the transaction in Vijay Tamuli's account is also available, lordship. Statements of the accused witnesses, lordship. Huge amount, lordship, 2,61,56,000, lordship. Not a fit case for anticipatory bail application, lordship.
What is the amount deposited into the account of Vijay Tamuli?
Separately, they have not given lordship. As a whole, they have given.
Their lordship, 3 lakh,
Small amount, 3 lakhs, 4 lakhs, that way.
3 lakhs.
Small amount.
Not small in the sense, not one time. Because he used to transfer it.
What do you
the
do,
brother.
Vijay Tamuli? What is your profession?
He is a teacher,
Teacher.
No, not teacher.
yeah.
He's a clerk.
Clark, lordship.
Clark.
Government school, Clark.
Working in school.
4 lakh,
School,
3
but he's
lakh
working.
get deposited in your account and you are blissfully unaware.
No, I have said it in para 5. He thought that brother has made some investment and those investment return he has sent to his account. That I've explained. But he was not aware that it was from the Fishery Mission Society. Some amount has come that he is aware. But the thing is that where it has come from, he is not aware. And the brother's statement, the Losel kindly says, Sanjay Tamuli, he must have told that he has done it everything himself. And he's still inside.
Bank account of Dipali Tamuli and Vijay Tamuli bearing account number respectively were used for illegal transaction of crores of government fund in multiple transaction from the government account of Fishery Mission Society maintained by SBI Assam Secretariat Bank. Also, lordship, statement given by the petitioner Dipali Tamuli is where as arrested accused Sanjay Tamuli that the bank account of the petitioner Dipali Tamuli handled and managed by the accused Sanjay Tamuli and need further verification, lordship.
Statement does not say anything about you. This statement does not say anything
Okay.
about you. It
Okay.
just says, yes.
But
He only
mother's
says
account-
beneficiaries. Some of them were real, some of them were fictitious. Does not say anything that you were not aware or anything of that.
Our instruction is that, because mother's account he used to maintain, this is a lady, old lady. Mother's, her statement has also been recorded, she has given her statement.
We will go a little further through the CD.
Mother, you are also protect because interim he recorded her statement.
Mother, I think we can protect, but this one we have to see.
That you also will see regarding the brother,
Symbol.
Marcel.
$22. Okay. Submitted. Non-appears.
Lordship, we have not received a CD. We have no instruction.
We have the instruction to trustee submitted in this case.
The interim order is there.
Yes.
Number one is 8 years. We can dispose of this. Add learned counsel for the petitioner. Additional PP submits that charge sheet has already been submitted by CS number.
190/25 dated 25/11/25.
Then is Java, order dated 17/11/25, paragraph 3. Para 5(2) deliver. Having regard to the nature of the allegations and the fact of completion of investigation culminating in the filing of the charge sheet. To take the petitioners into custody. Accordingly, the order of interim pre-arrest bail dated 17/11/2020 hereby made absolute. Order provided that the petitioners early participate in the trial if one commences and try to influence the witnesses in any manner. Petition stands disposed of accordingly.
May it be pleases you, Lordship. On the last occasion, your Lordship, trial court records has called for, and moreover, your Lordship, they have submitted that charge sheet has been filed. Your Lordship, on Amal Sarkar, your Lordship, not I am the pleading one, the petitioner. Here, your Lordship, that Amal Sarkar, your Lordship, already got the bail also, your Lordship. I would like to submit it here.
Have any information? Charge sheet has been submitted.
It has been submitted, yes,
Amal Sarkar, not against the petitioner, your Lordship.
yes, Lordship.
Your Lordship, he is
And again-
totally innocent, your Lordship, and false and fabricated case has been made up against her, your Lordship. Already, your Lordship, several occasion, your Lordship, I tried to locate that, your Lordship, FIR. Earlier, your lordship, it is the younger brother, and your lordship, the petitioner herself lost her family, your lordship. Only younger brother and her alive, your lordship. So, your lordship, as per your lordship, this FIR, your lordship, earlier, it is the younger brother who informed, who gave FIR, your lordship. Thereafter, your lordship, on the same date, time has different, your lordships. Another, your lordship, FIR has been filed by that, your lordship, deceased sister. So earlier on several occasions, your lordship, if teasing cases has already been, your lordship, lodged, an amount has already been transacted at his account, your lordship, Anupam Dhar. So, your lordship, it is totally false and fabricated to give her mental pressure, mental torture, your lordship. Nothing has been came out, and it is the police himself, your lordship, they have escorted her from your lordship where she is residing. At the place of occurrence, she is not here present.
Lordship, we have received a communication received, Lordship, from that information. Charge sheet submitted against the FIR and the accused person, namely Amal Sarkar.
Amal
Son
Sarkar,
of so-and-so.
he is on bail.
Against the petitioner, charge sheet was not submitted. Lordship, can this for the top.
Your lordship, trial court records may call your lordship, or your lordship, give her some.
Really?
Your lordship, Amal Sarkar, your lordship, that petitioner is already got bail, your lordship.
Heard learned counsel for the petitioner. Learned additional PP submits that charge sheet has been submitted by CS number
406/2024.
Right, CS number 68/25, dated 28 to 25. Against Amal Sarkar.
Amal Sarkar, not
against
the petitioner.
accused Amal Sarkar, but not against the present petitioner Navasmita. Order by order dated 14/2/25, the accused Amal Sarkar was granted bail by the learned additional session judge number 2, Nagaon. Having regard to the above. Actually, this has become infructuous.
Yes.
It's not named in the charge sheet. Where is the question of apprehending arrest?
Apprehending arrest.
View of the above, there remains no apprehension in the mind of the present petitioner regarding arrest in connection with the aforesaid case. Consequently, the present petition is structures and according closed as such.
This document can be kept in a record. This document can be kept in a record, was it? Part of record.
The communication this is from OC Rupohighat PS dated 15/12/25. Be kept as part of the record.
I'm deeply obliged.
24, we have not received. If the instruction was sought for whether any case is registered against the petitioner or not, we have not received any instruction, Lordship. Fix another, Lordship, we will try to get the instruction.
My lord, here it is a case, my lord. The petitioner received an information that one lady, my lord, lodged an FIR against the petitioner before the Nunmati police station, my lord. Here, my lord, here the fact is that, my lord, earlier, my lord, another FIR was
Learned
lodged against the
additional
petitioner.
PP submits that instructions as sought for has not yet been received. Prays for some time to obtain the same. Accordingly, list the matter again on so and so. In the meantime, no coercive action shall be taken against the present petitioner.
My lord, my lord. Highly obliged.
Please, Lord. Well, I was granted interim bail, my lord. Lord, this, my lord, petitions, my lord, should have been, the police should have been registered the case under section 1061, my lord. This is a case of an accident, my lord. Now, because of division bench judgment, my lord, now police now everywhere, if there is an accident, they register under section 105, my lord. there's a homicides not amounting, culpable homicide not amounting to murder. My lord, your lordship may kindly, if there is a direction from this honorable court of division bench that those who are cases, because 1062 has not been given effect to by the central government, my lord. And while there is a case registered, my lord, under 1062, my lord, so there's a PIL has been filed, my lord. And my lord, so the
So yeah, is the CD here?
No, charge sheets are being discussed.
Arshit submitted.
Yes, Lord.
submit করলি কি? Huh? Oh.
No question of apprehension.
Apprehension. No, no, the question of apprehension doesn't arise as charge sheet file under what? 105 cannot, my lord. That's what I am to say. Because of lordship, kindly see the division bench judgment. Is the case of an accident, my lord. The person has been died because of a road accident, my lord. And as there's a PIL which has been filed by this honorable here, my lord, the division has directed DGP not to register case under section 1062, my lord. So that is why they thought that all the cases which come out from the as a result of accident, they filed it 105.
But section is not mentioned here, Lord. Only the intimation is there, subsidy subject 100 case, Lord. Case number is here. And the case day was sent to CGM Jorhat.
Where is the FIR?
FIR is lordship will file at page, my lord,
Particular 1 and 12. And the
page your lordship will find 12, but vernacular, I just given you the vernaculars. Page 12, my lord. Based on vernacular and page 10, 11 as a translated copy, my lord. And this PIL has been filed, my lord. Your lordship on subsection, challenging the subsection 2 of 106, my lord. The last, my lord, has been, the last paragraph, what is here? However, the Director Central Police Assam should take note of the fact that issue of necessary direction to the police stations under the jurisdiction not to register any case under provision of subsection 2 of section 106 BNSS, which is not come into the force till date. So and so. So because of this, my lord, entire police throughout Assam and the state of Assam, they registered a case under section 105. After implementation of BNS, my lord, there is a strike by the truck drivers. And central government has withhold the subsection 2 of 106. Similarly, that was been challenged before this honorable court also, 106.
Under IPC, it would have been 304.
4A. A.
But now there is nothing.
No, my lord.
106 is not notified. There is nothing now.
1062, my lord. 2 has not been notified. 106 is now because of the PIL, my lord. All the police, my lord, they have because of the instruction, they thought they will register. They registered case under 105.
PIL clearly says subsection 2 of 106. Then why not under 1061? What is 1061?
1061 is this: the causing death by negligence, my lord. Whoever causes death of any person by doing any rash and negligent act, not amounting to a culpable homicide, shall be punished with imprisonment either discretion or term which may be extended to 5 years, as shall also be liable to a fine and such so and so registered under so and so term which may be so and so. It's a bailable offense, my lord. It's a bailable offense. 2 is not bailable. 2 is a different, because after that accident he has to go to the and report to the police, my lord, police station, my lord. Then two will not.
Or 19, 12, 25. Learned additional PP submits that in the present case, charge sheet has already been filed by CS number
141/25 dated 31/12/25.
However, he has no instruction as to under which provision of law, penal law, the same has been submitted. Para, be it as it may, having regard to the fact that the investigation is over, the nature of the allegations the custodial detention of the petitioners cannot be necessary. Consequently, the the order of interim pre-arrest bail dated 19/12/25 is hereby made absolute. It is further provided that the petitioner shall regularly participate in the trial if one commences and shall not try to influence or intimidate the witnesses in any manner. It is disposed of accordingly.
Obliged, my lord.
26 lordship, petitioner is on interim lordship. We have not received the case diary.
Interim to
19/2. 29 charge sheet submitted. None appears from the petitioner.
May I please, your lordship? Petitioner is an interim, my lord, and they have already appeared before the, their statements have also been recorded, my lord. Dispute between the, my lord, Bazaar committee and the informant side, my lord, and
Yes.
yes, no. Magistrate tribal case, my lord.
Hard learned counsel for the petitioner. Dated 9/1/26. Four. Learned additional 5. Learned additional PP submits that charge sheet has already been submitted. CS number
4/26 dated 20/01/2026.
is mentioned. No. Section not mentioned.
Section is mentioned, lordship.
Third
Under
section.
section 126(2), 191 subsection 3, 1172, 1182 under Venus.
Of which are magistrate tribal. Having regard to the above, and the fact that the investigation is over. What to do again, did you?
Obliged. Please, your lordship. The anticipatory bail application, case of dowry that, my lord, others are not a press for interim, but this petitioner before your lordship is the married sister-in-law who resides separately 2 kilometers away from the house of the informant, of the victim, my lord. Page 9 is the FIR, my lord. May I read it out, madam? Sir, most respectfully and humbly submitted by the complainant that I, the complainant, am a permanent resident of the above mentioned address. The description of the incident is that about 5 years ago from today, my younger sister Nandita Sarkar was married to opposite party number 1 as per Hindu social customs. After the marriage, she started family life with the accused number 1 at the address of the accused, and 2 daughters were born from their married life. It is to be stated that since about 1 year after the marriage, accused number 1 and his family members have been continuously subjecting my younger sister to various kinds of physical and mental torture by demanding dowry. As a result, several times mediation meetings and cases have also taken place. It is regrettable that this time also, by brutally beating my younger sister and driving her out, she took shelter in my house, and my younger sister filed a case in Honorable Gusaigaon Court. but the extremely dishonest and cruel accused persons by fraudulent promises executed an agreement and took my younger sister to start family life again. But the accused persons have stopped her from visiting or coming to any nearby relatives, neighbors, or even my house. Not stopping at that, on 2/12/2025, the above mentioned accused persons with conspiratorial intent administered poison to my healthy and sound younger sister and pushed her to the deathbed. Having come to know of the incident from a third person, my younger sister was first admitted to so-and-so hospital. This petitioner before your lordship, she is the accused number 2, the married sister who lives separately, about which we have stated in our petition in paragraph 6, my lord, page 4. And as per our instruction, this is a case of suicide, so perhaps abatement of suicide would come in, but it would be directed towards the husband and the family members who live in the house. She lives separately now.
Is there a section added subsequently?
We are not aware of that matter.
It is what dowry death.
Dowry death.
Heard, not for the petitioner. So and so. Paragraph 3. Submitted call for the CD. It is submitted that the present petitioner is the sister of the accused husband. He is married and lives in a matrimonial home separately from the accused and the victim. Accused number 1 and the victim. Therefore, to play, causing the abetting the death. The above it is of her arrest that so and so shall be released on interim bill of rupees with 1/0 order, provided that the petition appear before the IO within a period of 7 days from today and cooperate with the investigation. Again on
18 to 26. Deeply obliged, mind.
It pleases your lordship. Lordship, as per his office note dated 27/1/2026, service report in respect of respondent number 2 has already been received, lordship. But lordship, notice could not be served as the respondent is not available in the same location. So Lordship, we will be filing, we will file substituted service. So time may be given. Lord. We will file substituted service, Lord.
Available means change the location or you're not available at that time. What is not available in the given address and presently resides in Guwahati.
They should take first steps to after detailing the address of the Guwahati lodge.
As per office notes, the respondent number 2 would not be served as he no longer resides at the given address at Jorhat, and it is mentioned that as per process server's report, respondent number 2 is residing in Guwahati. There are petitioner to in proper address of the respondent number 2 and take steps accordingly the same manner. List again on
Wait, please, your lordship. Lordship, in this case, lordship office notes reflected 21/2026, lordship. The service report is awaited, lordship. Here, what happened, lordship? On 18/6/2025, lordship, we have taken a step, lordship. Then, lordship, court order, lordship, will find on 11/12/2025, lordship. If lordship allow, I may submit lordship in this regard, lordship, because the FIR lordship will kindly peruse the FIR lordship. Quashing of the charges, framing of charges under 376(1), lordship, that we have challenged, lordship. Kindly peruse the FIR, lordship, that is on page 18, lordship.
what will you do by perusing the FIR? Will that get over this problem?
Lordship, prima facie, lordship, 376(1) will not come, lordship. So for FIR, that is on page 18. Kindly
Does that
peruse.
mean we can dispense with notice on respondent number 2?
Lordship, PP can, lordship, it's a lordship, PP can appear, it's not on POXO case, lordship. I have annexed the 161 as
We have
well.
initiated the process, so only report of IO is necessary.
Yes,
As
lordship.
per office note, this has been issued to the Tamilpur PS by the registry, but report has been received. Full stop. Reminder for the to the OC Tamilpur. Yes. Is the matter again on?
Next week, lordship, or দুইবার step লওয়া হয়েছে। Can it be on 9? 10 February? Obliged, lordship.
None appears from the petitioner side.
None appears. List after 4 weeks.
May I be- For last court order, which your lordship has.
On 5/1/2026, your lordship is
Last
passed on.
court order 5/1/26. Your lordship had stated. Your lordship has stated that Archie so-and-so learned counsel, it is submitted by the learned counsel for the applicant that in respect of the order dated 20/11/25 passed by this court, there has not been any compliance of the, and the family court has already issued distress warrant, a photocopy of which has been submitted. Lordship,
Lordship,
that day
in fact,
also,
one
in
more
fact,
thing, one
your
more-
lordship would remember, on that day also, I have objected to the same which my learned senior had presented before your lordship. Lordship, that is the wrong submission, because I have got the certified copy of that order, lordship. Lordship may kindly peruse that order, lordship.
One more thing, your lordship, on that occasion, my learned friend submitted that there was a they're filing a SLP before the Supreme Court, and your lordship directed them to
That is
produce
also
that
there.
before
That
the
is-
sum.
That is also there, lordship.
Let them produce that.
Lordship,
Let
I
them
am just
produce.
pointing out that my learned senior had misled the court because.
No, I have not
that-
misled your lordship. There is
If
an
that,
order.
if that did not be the, so then your lordship may kindly peruse the order passed by the family court, lordship.
No, order to yes.
In this case, who is petitioner?
Lordship,
This order, who is petitioner means whom? You? Or them?
not them.
In the order on.
On last occasion, that is on 5/1/26, my learned senior had submitted before this honorable
I
court, and he had
submitted
produces a photocopy of the or photocopy also. I don't know from where he had got that photocopy, but this is the
No,
certified
it's a
copy which I
certified
have,
copy.
I have.
It was a
produced.
certified copy. It was a certified copy. I even have, is this a photocopy or a certified copy?
No, on that day you have submitted.
I have
because of which
submitted whatever I
an
have
order has
submitted,
been.
it is on
it
the
has
basis
been
of this
reflected.
copy.
It has been reflected.
Don't make submissions that I am misleading the court. I don't do that. Never in my life. How many years of practice you have? I have more than that. Don't make such submissions.
That's, I also admit.
I-
that is why
I'm-
have
he could
addressed
have
him
said
as a,
that there
as a
is a-
learned, as my senior lordship.
How can he say all these things here?
Lordship, it is.
I'm
reflected
saying
in
that
the
it
order
was
passed
there,
by
I
your
produced
lordship.
before your
It
lordship.
is, no.
If it is not there,
If that be so, then how can this order your lordship had passed based on the photocopy, lordship?
no, this is a certified copy. Andiya copy I read. Andiya copy. I've shown it to him. He sees it's a certified copy. Why is saying photocopy? All these such type of submissions. But why you are not producing the Supreme Court order? Produce it. Just making such submissions will not. Janu, gom paisa, olayan na copy to anybody.
What are we supposed to make of it now? This distress
Lordship-
warrant was kept in abeyance.
Yes, lordship, regarding
If
the. filing-
your lordship, 1 minute, just 1 minute, if there was no distress warrant issued on that day, how can it be kept on your lordship abeyance? If that is not passed, if I misled, let him answer that. If it has not been passed, how it can be kept in abeyance? Why, how he cannot say these things here? I'm very angry with this. Misleading, using the word. And when if it is kept in abeyance, that it has been issued once, that only it can be kept in
That is
abeyance.
what, lordship, before
Why
making any
making such
submission,
submissions?
before making any submission, my learned senior should know that what is the last court order. As I have already prayed before your lordship, that last court I was present, but he was not reluctant to hear me, lordship.
That question
That is not the way.
question is,
I produced the order. He did not produce the order. Why he did not produce the order? I produced the order where there was a distress warrant issued and the next date was fixed on 22/1. Lordship, that order is there before you, Lordship. 22/1. In between, how another
This
order
order
was
itself reflects that distress warrant was issued on 22/1.
But it has been kept in abeyance, Lordship.
By the next date,
Yes, Lordship. Till next date, Lordship. That is till 22/1, it was kept in abeyance. But unfortunately, 22/1, learned principal judge of the family court did not sit, Lordship.
So,
And moreover, we
what
have
way, Your
the
Lordship? Where
SLP,
is
that is a copy of the SLP, Lordship. I have the status of the SLP, Lordship. I have.
this is not the way. You are not paying it. Why you are making such submissions? I'm not asking for something else. We are asking for what is there in the division bench order. Always, Your Lordship, this is the way. It's not that way. I have never issued use such word against him. I could have said many things. I've never said. There are many instances I can point out. This is not the way. I don't like this type of submissions.
what was the main issue involved here now?
Main issue, Your Lordship, was last order was with regard to payment of the direction as per the direction of the Honorable Division Bench. Your Lordship directed that the amount of
Insurance
amount to be that was not paid within 2 weeks. That was not paid. He did not appear on that day. It was not paid. Now they come up saying that they have filed an SLP against that order. And Your Lordship directed that, yes, so you produce that order. In the meanwhile, there was a distress warrant issued by the family court, and the distress warrant was issued on 17/12, and the next date was fixed on 22/1. In between, before the next date, somehow it was kept in abeyance till 22/1. In between, I don't know when, which date, I don't know. I don't have a copy of that. Before 22/1, again they have listed the matter and passed the note. And when already Your Lordship's order is there with
We have-
regard to that distress one, and how they passed the order, I don't know.
We have not.
It was- I
listed
think
the
it was
case.
communicated.
The case was listed as per the consent of both the parties. Unfortunately, on that day, petitioner was absent, Lordship.
Whatever, Your Lordship, but Your Lordship has issued an order. With on the basis of Your Lordship order, how it can be kept in abeyance by a family court, you know? And secondly, Your Lordship,
Distress
anyway,
warrant-
anyways, Your
Distress warrant
Lordship.
is not issued by our Lordship.
No, distress was by the family court.
family
And
court.
once
And-
he issues, again, he kept in abeyance when this honorable court has already recorded that finding. So complicating the matters. Very simple matter, pay it. You don't have to, if you do not want to pay, say why you are not paying it, what is the problem, file an objection saying that this cannot be paid. When there is a direction of the Honorable Division Bench, what is the question of making all these submissions here and there, Your Lordship? Very simple case, making it so complicated. And otherwise, what is the necessity, Your Lordship, of me shouting here for that money, which is entitled to the petition? Not only that, Your Lordship, there are 3 issues that was decided. One is the regular, Your Lordship, maintenance of 6 that has been reduced to 50% on the stay order. That is still there. They are paying that. Secondly, insurance. And third is with regard to the amount to be 50% amount to be paid to the daughter of the petitioner. The respondent. And that is not been paid also. That is, they have disputed everything here and there. Again, goes back to the family court. You go for an execution. This is everything going on. You don't want to pay. Come and say why you don't want to pay. Decision can be made.
Your SLP is against the division bench order.
No, Lordship, against your Lordship.
Then this order is based only on the division bench's order. Then that has attained finality already.
Lordship. No, we have filed an SLP against the order passed by your Lordship, that I have already informed your Lordship in the last court, Lordship.
But that as this order was passed, Your Lordship, long back. I don't know when they have filed the SLP. I have not been given any copy of that also. You filed question SLP.
We have already passed the order in your favor. Now you go before the family court and get it executed.
That is why, your lordship, we went. Distress warrant was issued. They again.
No,
with-
your family court has said that opposite party is directed to furnish the latest order of the High Court.
Yes,
Furnish it.
we have furnished your lordship's order. We have furnished that.
So then distress warrant will resume.
I don't know, I don't know.
What
Problem is
order
that
do you
see what has happened?
What
that
do you
this-
expect from us now?
I understand, your lordship, there are so many problem is this complications, your lordship, making it so complicated. There is a simple case, your lordship. Why it has to be made so complicated, I don't know. Now, whether the Supreme Court, before the Honorable Supreme Court, they have filed a case, maybe they have filed a case. What is the status, how it has gone, nothing has come up. If there is a stay order by the Honorable Supreme Court, then fine, your lordship's order will be stayed. Otherwise,
he has to
if the order
produce.
prevails,
That he has to produce if there is a stay order.
there is no stay order, I think. There is no stay order. If there is no stay order, the earlier your lordship's order prevails till if it is stayed or
I
whatever.
don't think it has yet been registered because this is a diary number only. SLP number is also not there.
Yes, lordship.
Status is pending.
Then
So it's
in-
as good as nothing.
nothing, your lordship. Just filing a case there doesn't make any sense. Now, your lordship may just issue an order to approach the family court with the lordship's order, and the family court will pass appropriate order on that. We'll do that. No, they have stopped totally paying anything, your lordship.
No, we are paying the monthly.
Only
maintenance.
monthly part has been
How
paid
can
to
my
the
learned
daughter.
Senior can
To
submit
the
that.
daughter, it has been paid.
Submit that
That is
submission.
the only thing they have.
Heard learned counsel for the petitioner and learned counsel for the
50%
respondent.
you have not paid. Admit it.
There is the
You have
order dated 23/12/25 passed by the learned principal judge, family court 1, Kamrup. Hereby the distress warrant against the opposite party has been kept in abeyance and the opposite party therein was directed to furnish the latest order of the High Court. In the present case. In view of the above, and for the parties to apprise the learned principal judge regarding the orders passed by this court. Make file appropriate application, if any, is required to be filed. The said court below. Do we keep this pending for, or do we dispose of this?
Which one?
What is the other,
Now, their application is only that so SLP has been filed. That is
main application,
main
but
application may remain. Let it be related. Because nothing is being coming out here, even after orders from this one.
so the IS stands disposed of.
Which I also
This one 766, wherein this order for payment was to.
let it remain, your lordship, because if it has not yet been paid, your lordship, that is why. I'll bring in the order which will be passed by the learned family court. Lordship may fix it on within a period or something like that.
Well, at least the matter again on.
Till then, your lordship, I may, if whatever order is passed, I'll place before your lordship.
Lordship, in the meantime, in criminal revision 345 of 23, there is an interim protection, Lordship. Interim order may continue, Lordship.
That is continuing, your lordship. That has been continued.
Interim order passed
Yeah,
earlier in
filed any vacation order.
criminal revision 345.
Of 23.
That is
Continue till the next date of listing.
50% of the amount is being allowed to be paid. That's it.
50.
We are the pay. We are not objecting to that. Anyways, obliged to you.
36. 36.
The 2011 matters.
On
What is
other several
appearing?
occasions, none appears.
They have become infectious also.
Arising out of complaint case, Lordship.
Hmm.
Arising out of a complaint case.
Maybe complaint case itself has been disposed of by now.
Per se party also have not entered appearance. Probably there is a interim, maybe. I have one order. Order sheets are from 2013, but the case is of 7. Up to date, the order sheets.
Interim order is there.
I have seen interim order shall continue, but when
I think original records are here. Yes, interim is there. But extended till 23/3/2011. After there is no extension.
the record is here, Lordship, then
Same thing.
by amicus.
The record here.
TCL.
Yes, TCR is here. कोई नहीं है तो प्रोसीड हुआ नहीं पता करने के whether she is alive or not, that also we don't know. Let us issue a court notice. Because suppose she is no longer there or something, then pointless exercise. None appears for the petitioner. It is seen from the order sheet that on previous dates also none appeared for the petitioner. PCR of the case is available. Accordingly, I consider it fit to issue court notice petitioner, registry, take necessary steps. Is the matter again on
Steps upon the petitioner.
registry?
Right, please, your Lord. Very old case, my lord.
Yes.
And we don't know the opposite parties are still living or not. My learned friend can say that. my lord.
No, I do not, no knowledge. I have no telephonic connection also, my lord. No number is also there, whether surviving or not, these respondents are. It is a 2011 matter, my lord. Whether there was no stay order, I think, from the High Court.
No, a question of stay order doesn't have.
So that, I think the
revision
original
petition was
matter was
allowed.
also disposed of in the court below.
Revision petition was allowed in your favor.
Yes. You have
Against that,
challenged it.
against that, I have approached your lordship. My lord, can I suggest one thing?
Yes.
Let it be taken up on 10th of February, madam. I have to go through the LCR and also I will take instruction from my client.
Where is the client situated?
Kokrajhar, madam.
So you have means of communication.
I have his phone number, madam. I will contact him, madam. And
As prayed for by Mr. G. Boycer, learned counsel, appearing for the petitioner, seeking time to obtain instructions from his client. List the matter again on 10th of February.
10th of February. Right.
Yes.
The other side has not yet come. my lord. Hey, proceed, my lord. This is a case, my lord, under section NIA. The learned First Appellate Court imposed a fine of ₹6 lakhs and sentenced 3 months SI. My lord, what happened? Though we filed the appeal, now we have.
All right,
come-
let us have it on another date.
My lord, they may, I will inform you at 2 p.m., my lord. They will be here because they did not expect that it will reach so early. At 2 p.m., let us come.
All right.
Matter relating to, my lord, a conviction in a CBI case, my lord. Standing counsel of CBI is not there. There were 2 appeals, 1 appeal, my lord, one of the appeal expired, now this appeal is pending. my lord. We have also prepared 1 paper book, my lord.
Should we wait for the other appellant also to join the
No, he expired.
earlier one?
He expired, my lord. The
No.
appellant, my lord.
Should we wait for the present appellant to join him?
No. The lordship, my lord, actually, they have not seen her also, Manorama, my lord.
Not come.
I could start it, but
Learned counsel,
your lordship may fix a short date, I will inform him right accordingly.
yes, yes. The petitioner, Mr. P. could cover learned counsel for CBI is not found present. Is the matter again on
Next week, my lord, any day.
May I please, your lordship? The senior counsel has brought report number here, NSA method. And
Yeah, in this case, CS submitted, Lordship. Yes.
Tomorrow. Kindly, lordship, some takes, so he may argue on this matter. Some contradiction on this case, so. Tomorrow, kindly.
the prayer of learned counsel for the petitioner is the matter again on day after tomorrow. Oh,
So
tomorrow.
separate and-
Tomorrow.
Bless.
We two holding. Him to wiggle.
Item number 2 was, well, he was supposed to inform your lordship regarding the search sheet. madam.
Some other PP was there, I think, or you.
Information we have not received, Lordship. We are trying to contact her. Can you fix it on tomorrow, Lordship?
All right, tomorrow. The prayer of learned additional PP to enable action as to whether charge sheet has been submitted in the case. One.